Good morning, meet arbitrators, member tribunals. My name is Quân. I am the counsel for the Claimant, Ellipse Oil Company. My two co-counsels are Ms. Phương Nguyễn and Mr. Hiệp Nguyễn. Together, we are our trio 41 from the Diplomatic Academy of Vietnam. Mr. Arbitrators, Member Tribunal. For the first 4 minutes, I will present the jurisdictional matters of the case and claimant's comment on CSE request. For the remaining time, my two co-counsels will present the merits part. Now, I will begin the submission of claimant. Mr. Arbitrators, Member Tribunal. Claimant respectfully submits that the tribunal has jurisdiction to hear this case because of 3 reasons. First, claimant made an investment in accordance with the EVFTA. Second, claimant is able to submit the present dispute to the tribunal. And last, claimant observed the cooling-off periods with the futility exception of consultation period. Claimant will demonstrate these arguments respectively. Firstly, the license agreement between the verdict government and the ESCO is an investment pursuant to the EVFTA because it has characteristics of a concession contract. A concession contract is a list of forms of investment protected under the EVFTA. Furthermore, it is owned indirectly by the claimant through a subsidiary in the verdict territory, ESCO. Secondly, claimant is able to submit the present dispute to the tribunal because it is an investor acting on behalf of its locally established company, which is ESCO. And although claimant is state-owned, it is still qualified to submit a case under the investor state proceedings because its activities are mere commercial and don't constitute governmental functions. Lastly, claimant submits that the bypass of submitting a request for consultation is an accepted futility exception, thus it could not be used to challenge the jurisdiction of the tribunal. This argument is supported by prior cases in practice of international investment law, such as Alps versus the Slovak Republic. Moreover, series of actions in the fact demonstrate that while claimant attempted to settle the dispute through amicable resolution, the respondent, on the contrary, refused to take it. A formal consultation period, therefore, is definitely futile and claimant has a right to bypass it. In conclusions, with the 3 reasons set out above, the tribunal has jurisdiction over this present case. Mr. Arbitrators, Member Tribunals, regarding the CSE's request, claimant strongly opposes because of 2 reasons. First, there is no need for amicus curiae in this proceeding and therefore the presence of CSEs is definitely unnecessary. Secondly, and most importantly, the involvement of an MTO in the proceeding as a non-disputing party may cause detrimental effects on claimant, which turns out creating despair and more burdens on claimant. In conclusions, claimant's opinion is to oppose the request of CSE. Mr. Arbitrators, Member of Tribunal, that concludes my submission and I will hand over to my 2 co-counsels. Thank you for your time.
Mr. Arbitrator, Members Tribunal. For the next 3 minutes regarding the merits part, I will present 2 issues, including expropriation and national treatment. The claimant submits the respondent violates Article 16 of the EVFTA by demonstrating that there was an expropriation. The expropriation is unlawful. Firstly, respondent seizures of the oil wells amounts to indirect expropriation. It has been consistent in international law, land tickets or when hotels, that an investor contractual rights are capable of being expropriated. In the current case, Vertex interfered with claimant's right to drill and explore the oil wells to an extent to render its rights useless. Although the formal title of the license remains, with the oil wells transferred to NPCV permanently, claimant will no longer be able to make further operation. Secondly, claimant submits that the expropriation is unlawful, since respondent failed to satisfy the requirement of public purpose and due process of law, and respondent cannot provide evidence showing action made by NPCV to remedy the damage caused by the oil spill. Claimant argues that such measure is not for genuine interest of the public, but for economic gain. Moreover, the due process of law requirement is also not met, as respondent transferred the oil wells to NPCV without advance notice and did not give claimant the opportunity to have the case reviewed before an independent and impartial body. Lastly, as an expropriation will not be lawful without compensation, even in the case of an environmental expropriation such as in Changzhou factory case, the tribunal should conclude the respondent is obliged to restore claimant's investment and pay an adequate and full compensation. That concludes my submission for expropriation, and now I will move on to the next arguments concerning national treatment. Claimant submits the respondent failed to accord national treatment to claimant under Article 3 of the EVFTA by demonstrating that claimant and NPCV are in line situation and there is a different treatment towards claimant. In the present case, both NPCV, the domestic entity, and claimant, the foreign investor, operate in the oil sector. It is stated in Pope and Tabo that difference in treatment requires an unreasonable relationship between the treatment and the rational policies. In this case, instead of taking joint efforts, claimant to remedy the damage, respondent unreasonably transferred the oil wells to NPCV, an opponent company of ESEO for economic gain. Therefore, the tribunal should conclude the respondent breached its national treatment provision. Mr. Arbitrator, members of the tribunal, that concludes my submission, and I will hand over to my co-counsel. Thank you for your time.
Mr. Arbitrator, members of the tribunal, for the next 5 minutes, I will talk about how the respondent violated its obligation to accord fair and equitable treatment to claimant. Firstly, the principle of fair and equitable treatment is part of the bona fide principle of international law. In the EVFTA, this principle is codified in Article 14, requiring the contracting party to accord fair and equitable treatment to investment and investor of the other party in its territory. Mr. Arbitrator, member of the tribunal, respondent has breached this obligation because of two reasons. Respondent amendment to the OPA violated the claimant's legitimate expectation, and their conduct constitutes abusive treatment of investors. Firstly, in the agreement between the claimant and the respondent, there is no mention of liability for removal and damage remedying costs. The respondent's amendments to the OPA significantly altered the obligation, as agreed between the two parties, by widening the scope of the obligation, making the claimant liable for all removal costs and resulting damage in the event of oil discharge. The amendments also broadened the scope of the term damage and the safety obligation, as well as include a retroactive effect for all claims arising from an event before the date of enactment, which retroactively affect the claimant. All of the amendments means that the respondent had imposed a new obligation upon the claimant, the obligation to compensate for all removal and remedying costs of both parties in the event of oil discharge, which went against the legitimate expectation of the claimant for a stable legal framework during the investment period. Secondly, respondent conduct constitutes abusive treatment of investor as regulated in the EVFTA. First of all, the respondent amendments to the OPA constitute an abuse of legislative power because it was made under public pressure to specifically target claimant and impose upon it a new obligation. Next, failure to answer the claimant's claim for declaratory relief is a bad faith conduct. The negligence on the respondent part in response to the claim of the claimant for such a long period of time is an act of bad faith that violated the fair and equitable principle. Finally, the public accusation of the respondent to the failure of the claimant in remedying the oil spill is a bad faith conduct. Mr. Arbitrator, members of the tribunal, now I will talk about the reason why the claimant does not bear responsibility for the damage caused by the oil discharge. First of all, the oil discharge did not happen because of the claimant's action. Secondly, the claimant has fulfilled its safety obligation in the agreement.
Mr. Arbitrators, member of the tribunal, thus claimant's submission regarding the present dispute. Thank you for your time.